Welcome back to the deep dive. Today we are getting into some really foundational stuff in the U.S. patent system. We're looking at MPP Chapter 400.
Yeah, specifically Section 401. It's short, but wow, it defines a really critical boundary for the USPTO regarding who represents you.
Right. So our mission here is to unpack MPP Section 401. This is the rule that, well, it forces the USPTO to stay quiet, essentially, even if you, the inventor, are really struggling and need help finding a lawyer or an agent.
Exactly. It's like an institutional firewall. You know, the USPTO examines the patent, they grant the rights, so they absolutely have to appear impartial.
Above reproach.
Completely. They can't be seen playing favorites with practitioners. This rule really sets out the ethical lines for the office itself.
So here's the paradox for you listening. You've got this amazing idea, you file your application, and then, you realize you're totally swamped by the procedures.
Happens all the time.
You desperately need a pro, but the office that knows the most about who's qualified, they're legally forbidden from even giving you a nudge in the right direction. How does that even work? How does the system square the inventor needing help with the office needing to be neutral? That's what we're diving into.
Let's get into it.
Okay, so segment 1. This mandate of neutrality. Let's start with that core rule in 401. USPTO cannot help you pick a patent practitioner. Obvious reason, right? Avoid conflicts of interest. But what does that actually mean day to day for an applicant?
Well, it means the whole burden, finding someone, checking if they're qualified, vetting them, it's all on you, the applicant. The sources are clear. You basically have two paths.
Okay.
You can represent yourself, go pro se, as they say, or you authorize one or more registered patent practitioners to handle things for you. That could be an attorney or an agent.
And that distinction, attorney versus agent, that's another layer of detail right there, isn't it? Just understanding who can practice.
It is, and it's important. Both have to pass the patent bar. They're registered with the OED, that's the Office of Enrollment and Discipline, but only the attorney can, practice general law, handle litigation if it comes to that.
But the USPTO's neutrality, it applies to both equally. They can't hint that an attorney might be better or an agent.
Nope. Zero endorsement. They stay out of it completely.
Okay, here's something I found really striking in the material. The rule about juristic entities, big difference there. If you're an individual inventor, you choose pro se or hire help.
Right.
But if the patent owner is a company, like a corporation, no choice. Why is that? Why treat a company as, less capable of representing itself than a person?
That's a critical point. A juristic entity, think corporation, partnership, LLC, it isn't a natural person in the eyes of the law, so it can't technically act pro se.
Oh, okay.
These entities it's mandatory, be represented by a registered patent attorney or agent.
So wait, even if you have, say, a super knowledgeable CEO or an in-house engineer at the company, they can't just sign off on patent filings or amendments.
Absolutely not. Not unless they're personally registered to practice before the USPTO. The rule enforces that layer of professional accountability for organizations. Yeah, the USPTO needs assurance that the entity gets the complexities, procedural, technical, ethical. It's sort of a safeguard, making sure there's always someone involved who's accountable to the OED, the disciplinary body.
So it underlines that corporate IP, because of its scale maybe, needs that formal professional representation right from the get-go.
Precisely.
All right, let's shift gears. Segment 2, the pro se inventor. This right to represent yourself is often talked about as this great democratic feature of the patent system. Access for everyone.
It is, in principle.
But then, boom, the sources hit you with this big, but 37 CFR 11.18. That's the rule about certifications and, sanctions.
Yeah, that's the accountability piece. Immunity isn't part of the deal. The MPP is very clear. Anyone, whether you're a first-time inventor, acting pro se, or a patent attorney with 30 years experience, if you sign and file any paper with the office, you're making the exact same legal certifications under 11.18.
Hold on a sec, though. That seems harsh. If I'm just an inventor, maybe I've never even seen patent law before, how is it fair to hold me to the identical standard as a registered professional who studied for this, passed the bar exam? Doesn't that kind of undercut the whole pro se idea?
I see why you'd say that. It feels like a tension, definitely. But the USPTO sees it as necessary for the integrity of the whole system. Think about it. The office has to be able to rely on the documents filed, the claims, the facts presented.
Okay.
So 11.18 basically makes you certify, under penalty of, well, bad consequences, that what you're submitting is truthful and filed in good faith. You're certifying that anything you state as your own knowledge is true, and anything based on information and belief you believe to be true after a reasonable inquiry.
So it's not just about lying. It's about certifying you did your homework, essentially. Due diligence.
Exactly.
What happens, practically speaking, if a pro se inventor messes this up? Maybe not intentionally, but just through misunderstanding.
The consequences can be really severe. Now, for a registered practitioner, violating 11.18 could mean OED discipline suspension, maybe even disbarment, public shame.
Right.
For the pro se inventor, the sanction often hits the application itself. The paper they filed might get thrown out. The entire application could be struck. Or, maybe worst of all, if a patent actually issues, it could later be found unenforceable because of inequitable conduct or fraud on the office traceable back to that faulty submission.
Wow. That sounds more immediately devastating for the inventor's actual goal. You mess up the process, you could lose the patent entirely.
It really underscores your point. Knowledge is key. Misunderstanding or misapplying the rules, even unintentionally, can sink the ship.
Yeah. The system doesn't grade on a curve just because you chose to go it alone. You're still responsible for meeting the standard, including that duty of candor and good faith.
Which is really the bedrock of the whole patent prosecution process.
Okay, this leads perfectly into segment 3. The examiner's tightrope walk. This is maybe the trickiest part of Section 401. You've got the examiner who's supposed to be neutral.
Mm-hmm.
But they're also experts. They see pro se applicants making potentially fatal mistakes every single day. How do the rules tell them to handle that? When they see something that could be patented, but it's being botched by lack of know-how.
It is absolutely a tightrope walk. The MPP does allow, even sort of encourages the examiner to suggest seeking professional help, but only, and this is critical, if two things are true.
What are they?
One, the application looks like it actually contains patentable subject matter, so there's something potentially valuable there. And two, the applicant clearly seems unfamiliar with how to properly draft claims or, navigate the back and forth of prosecution.
So the examiner's trying to prevent a good invention from dying due to procedural errors, but without actually giving legal advice.
Precisely. They can suggest getting help, but, and we have to hammer this home, they absolutely cannot suggest who to hire.
That's the hard stop. The absolute restriction. The second they mention a name, a firm, anything specific.
They've crossed the line. USPTO neutrality is compromised. Big problem.
Oh, how do they manage this? How do they suggest help without recommending?
Well, to keep it consistent and professional, the MPE actually provides specific, very carefully chosen language. It's a standard paragraph, often called form paragraph 4.9 internally.
Okay, let's break down that form paragraph.
Yeah.
Because the language itself seems like a pretty strong systemic warning from the USPTO. What are the key things it tells the inventor?
Right. First, it acknowledges upfront that patent law and the whole examination process are complex. No sugarcoating it.
Good start.
Second, and this phrase really jumps out, it warns that going it alone without professional help might lead to, and I quote, missed opportunities for optimal protection.
Missed opportunities for optimal protection. Wow. This is incredibly direct for government language. It's basically the USPTO saying, look, your invention might be great, but your paperwork could limit your rights.
Exactly. If the examiner sees common mistakes like claims written way too narrowly or a description that doesn't really support broader possibilities, that warning is meant to signal a real risk.
It connects the dots for the applicant, right? That the ultimate strength, the scope, the value of your patent often hinges on how skillfully it was prepared and prosecuted.
Yes. It's the office formally cautioning you that the DIY approach, while perfectly legal, is inherently riskier if you're aiming for strong, broad protection.
And then, crucially, after delivering this pretty stark warning, the form paragraph has to pivot back.
Always. It has to end by restating that core rule. The USPTO cannot, under any circumstances, get involved in selecting or recommending any specific patent practitioner. Neutrality above all, that's the final word.
So let's say the inventor hears that warning, missed opportunities, and thinks, okay, maybe I do need help. Where does the MPP point them since the examiner can't give names?
It directs them to the official public resource, the USPTO's own directory of registered patent attorneys and agents. It's available online, or you can ask the OED, the Office of Enrollment and Discipline, for it.
So it empowers the inventor to do their own search among the pool of qualified registered professionals. The choice stays entirely independent of the examiner and the USPTO itself.
That's the idea. Maintain neutrality while still pointing towards a solution.
Okay, wrapping this up then. This whole dive into MPE Section 401 really shows how the system tries to protect its own integrity, doesn't it?
Absolutely. It keeps that crucial line drawn between examining the patent and advising the applicant on who should represent them. It's a balancing act.
Respecting the right to go pro se, but also implicitly, maybe even explicitly with that form paragraph, acknowledging the high standards and complexities involved.
Right. The system admits it's complicated, that's the examiner's warning, but it firmly places the responsibility for navigating that complexity outside the USPTO's domain. It preserves impartiality, but maybe at the cost of, offering a more direct helping hand to the individual inventor who's struggling.
So let's leave you, the listener, with a final thought to chew on, building on this tension. If that examiner's warning language flat out says skillful preparation is key to maximizing patent value,
Warning about those missed opportunities.
and if big companies, juristic entities with lots of resources, are actually forced by the rules to hire professionals, what does all that really tell us about how feasible the pro se option truly is for an individual who wants the best possible protection for their invention?
Is the right to file pro se a genuine path to top-tier IP, or is it more like just getting you in the door to a game that really demands expert players for the best outcomes?
Something to think about. It really digs into that question of access versus actual optimal results in the IP world.
Definitely food for thought.
Okay. And before we wrap up, on behalf of our team, a huge thank you to Mike Shepard, the creative director who put this whole audio series together.
Yes, thank you, Mike. And finally, just the necessary disclaimer. This summary of the MPEP was put together using AI tools, including ChatGPT and Notebook LM. It might have errors or leave things out. It's really just for general educational info.
Definitely not legal advice or a substitute for proper training. For the official word, always go to the official MPEP itself or talk to a qualified instructor or a registered patent practitioner.
Absolutely.
We'll catch you on the next deep dive.